We're back with James Zirin, we're the author of The Mother Court, and we were talking about the possibility of the fact that we're not trying terrorists in American courts, and we're trying them in military courts in Guantanamo. Is there a possibility, Jim, that maybe the government would be afraid that the confession by Muhammad would be thrown out because it was the subject of torture? Are they afraid that some of that would come out in a public trial, you suppose?
Well, I think in the military proceeding, if there was a coerced confession by Khalil Sheikh Mohammed, it would be excluded from evidence. That's true. But if a coerced confession by a witness would not be excluded, or a coerced statement by a witness would not be excluded, and that's what makes it different from the civilian court. The concern of the government, part of its concern has been that the defense would demand classified information from the government files, which they might find helpful to the defense, and that the civilian court might give them this information, or if the court, if the government did not want to give up the information, that the court would dismiss the case. Well.
But that's true in any case involving...
That's true in any case, and actually, in all these terrorist cases I've referred to, that was an issue, and the court was perfectly capable of screening the information, determining what was relevant to the defense, and weighing that against any possible compromise in national security.
We have this government now that's so secretive that we can't, even when we're trying to defend ourselves in court, the government refuses to provide the information that they know about.
That's right, and it's dangerous.
Yeah. So, is there a possibility that any terrorists? So right now we've got how many terrorists are currently in Guantanamo? Do you know?
I think that it's about 150. And I'm not sure the precise number.
And are they being held without charges?
But they're being detained without charges. They haven't been indicted, and the Supreme Court has said that you better charge them pretty fast so they have habeas corpus rights.
Well, it's a fascinating subject. I think we'll move on, but it's a subject for another show. And I'm sure you have your co-host of your own television show. Tell me about that.
Conversations in the Digital Age, which is on CUNY TV in New York and also on WNYE TV in New York.
And how long have you been doing that?
I've been doing that for about 10 years.
Wow. Because I noticed from your afterward, I guess, that your first love was journalism, and now you're doing it again, apparently. You've, after 40 years.
Well, as a it's a form of journalism.
Right, exactly. You started out as a journalist, you went to Princeton, and then you were covering a murder trial, apparently, and liked it so much you decided to become a lawyer. That's
right. That's exactly how it happened.
And very successful one, it looks like. Well, listen, the fascinating, the Rosenbergs occupy quite a very colorful part of this book, a subject I really didn't know much about the Rosenbergs till I read your book, and it's fascinating to me that, according to Ethel Rosenberg apparently was just not guilty.
Well, I think that's correct. She may have been aware that her husband was engaged in a spying operation, but she was not guilty. But my real quarrel with the Rosenberg case is not guilt or innocence. My problem with the Rosenberg case is the sentence of death, which was imposed on both of them. And I believe it was an illegal, and I argue in the book that it was an illegal sentence. And I could elaborate and tell you why it was illegal, but it was basically they were indicted under two statutes, the Espionage Act, which called for the death penalty, and also the Atomic Energy Act. Now, they're really commonly thought of as atomic spies, although the secrets which were given over, except for one small sketch which was of no use to the Russians, the secrets that were turned over related to a different kind of classified information to make weapons and munitions and so forth. So, but they were indicted under both the Espionage Act and the Atomic Energy Act. which covered various periods in the conspiracy. Now, the Atomic Energy Act, I argue in the book, and as did three justices of the Supreme Court, superseded the Espionage Act, and that provided for the death penalty only on jury recommendation.
Right.
In this case, there was no jury recommendation, so
amazing.
The sentence was illegal.
A judge.
Secondly, the sentence was totally disproportionate to the crime. I mean, people like Klaus Fuchs, who really did turn over important atomic secrets to the Russians, got 30 years, and other people involved in the Rosenberg conspiracy, including Mrs. Rosenberg's brother and sister-in-law, either got no sentence at all, weren't prosecuted, or received relatively light sentences.
And Julius, the brother, or Julius Rosenberg, was executed also. And
that's the husband. Julius Rosenberg was Ethel's husband. David Greenglass was her brother, who turned state's evidence and testified against her and his brother-in-law.
And the Russians later said that the Rosenbergs gave them really no useful information, or maybe accelerated their atomic bomb program by no more than a year at the most?
Well, they didn't even say that.
Yeah.
Of course, with the downfall of the former Soviet Union, all of the documents were released, and it appeared that the one very important Russian security expert, whom I quote in the book, said that you fried Julius Rosenberg for nothing. None of what he gave us was of any use in constructing the atom bomb.
And we had a judge, Irving Kaufman, who imposed this death sentence. Tell us about him and how all that came about.
Well, Irving Kaufman was a very bright, very ambitious district judge. He wanted to go to the Supreme Court. He was apparently selected for this case, as were the two prosecutors, because he was Jewish, as were the two prosecutors, Roy Cohn and Irving Sapol, because the Rosenbergs were Jewish. And as often happens in such situations, particularly at that time and that period of hysteria, it appears that Kaufman bent over backwards to deliver a harsh judgment against the Rosenbergs. I mean, in his sentencing statement, he said they were responsible for the deaths of thousands and thousands of Americans in Korea. Now, there was absolutely no evidence of that whatsoever. And he made a number of rulings in the course of the trial with regard to the admissibility of Mrs. Rosenberg's taking the Fifth Amendment in the grand jury, and then changing and testifying about it at the trial that would not be permissible today. But if it was permissible then, well and good. But as I said before, my quarrel is with the sentence of execution, the sentence of death, and the execution of the Rosenbergs, as the New York Times acknowledged, continues to haunt the American consciousness to this day. And it was the sentence was really represented in my view, a miscarriage of justice.
And was that matter appealed to the Supreme Court?
Yes, all the way to the Supreme. It wasn't appealed to the Supreme Court. The Supreme Court denied cert.
They denied to review that case.
Yes, with three justices dissenting. Actually, there was a rush to judgment because when the case went up to the Supreme Court, including this substantial question about whether the sentence was legal, the Chief Justice, who was then Fred Vinson, brought the court back from vacation, which was rather unprecedented. I mean, what was the urgency? Where were the Rosenbergs going to go? They were both in Sing Sing on death row, and brought them all back from vacation, and then denied the stay which had been granted by Justice Douglas,
right,
as improvidently granted, and so with the stay denied, the Rosenbergs were executed. And three justices dissented from the vacation, I guess you'd call it, the vacator of the stay, and those are Black, Douglas, and later Frankfurter.
So Douglas issues the stay, and rather than just let the stay in place until the Supreme Court can do a thorough review of it, maybe even grant cert and review the case, they came back and immediately just overturned the stay and then denied cert?
That's right. Well, they didn't deny cert. They just, having dissolved the stay, the execution proceeded, and so it made the petition for cert moot.
But Kaufman's ruling was never reviewed by the Supreme Court.
Never reviewed by the full Supreme Court,
right.
although his ruling was reviewed by both in opinions dissenting from the stay ruling by Black, Douglas, and Frankfurter.
Now, I guess under that statute, a judge can issue the penalty. Now, there's no longer a statute. Is there any federal statute now that would allow a judge to impose a death penalty without a jury?
Well, there was a jury in the Rosenberg case. The Espionage Act is still has vitality. It's sort of an oldie but goodie.
So the jury in the case recommended death.
No, the jury in the case convicted, but did not recommend death.
That's what I'm saying.
On the basis of the conviction, the judge imposed the death penalty.
Right, but in today's world, at least I do a lot of capital work, of course, and you have two proceedings. You've got a guilt phase, then you have a death phase, and it has to be unanimous in Virginia. A death, the jury has to then decide penalty. So in that case, they recommended conviction. The jury did, but the judge imposed a death sentence without a jury recommendation.
That's right, but there was no statute, no federal death penalty statute as there is now that would have required a jury recommendation.
Right. So
there was a statute that required a jury recommendation, and that was the Atomic Energy Act, which Judge Kaufman totally ignored.
Yeah, because that came into effect in 1946, and your argument is that statute superseded the other statute, the Espionage Act, and since most of the acts that they were accused of doing were back before 1946, that's your argument, right?
Well, that's true, and also it couldn't. The judge sent the case to the jury on giving them the language of both the Atomic Energy Act and the Espionage Act.
Mm-hmm.
So the jury had to consider both atomic secrets and non-atomic secrets. And the jury came back and just convicted, and no one knows whether they convicted of atomic secrets and non-atomic secrets or both. And if atomic secrets entered into it, as would appear to be the case, because the judge said you passed atomic secrets to the Russians, which caused the death of thousands of people in Korea, even though the Russians never used the atom bomb against us in Korea. I mean, it was just preposterous. The Atomic Energy Act required the death penalty, required a jury recommendation to have the death penalty. And so there was no jury recommendation, so what he did was illegal.
Amazing. That's just your career, your 3-year career. Did you prosecute mobsters?
Yes, I did.
And you talk about the mob. The mob's always colorful. Why don't we tell
Always colorful. Well, I started out with, we talked about what I read about when I got to the office, and the U.S. Attorney's Office, and one of them was the Appalachian case. And the Appalachian case was a meeting of 100 mobsters in upstate New York.
Right, you talk about that in your book.
And the government didn't know why they were there. They all were visiting a man named Joseph Barbera, who owned a farmhouse in Appalachian. They all descended from all over the country. The 100 mobsters descended on this farmhouse. And then an FBI state trooper task force went in and broke up the meeting. And the mobsters ran into the woods, strewing $100 bills behind them. No one knew what the $100 bills represented, but they just didn't want to be caught with them. And they all gave the same story to the police as to what they'd been doing there. The government was never able to prove what they'd been doing there. And they all said they'd been visiting Mr. Barbera, who was ailing, and they wanted to commiserate with him. One guy said he went there because he was delivering fish. Other than that, everybody had told the same story. Now, this meeting was later fictionalized, both in The Godfather and in I think the movie Analyze This. And the meeting was supposed to make the peace between Frank Costello and Vito Genovese.
Right. Okay.
But the government didn't know it at the time, and they were unable to prove what the purpose of the meeting was. They arrested and indicted. They arrested a number of them, but they wound up indicting 20 of them. And they were convicted, interestingly enough, before Judge Kaufman of Rosenberg case fame. And then the conviction was reversed on appeal because they said there was insufficient evidence of a conspiracy. And it was a very interesting mob-related conspiracy case.
Well, you make a reference to Analyze This, and also Tony Soprano. Elaborate on that a little bit. That's funny.
Well, I think in the fictionalized accounts, and I think it later came out in the testimony of Valachi, the meeting occurred so that to make mob peace. Now there was a war going on, a mob war between for control of the organized crime syndicate between Frank Costello and Vito Genovese. Costello had a henchman named Albert Anastasia, who was whacked in a New York City barbershop. And as a matter of fact, the barber chair that he sat in is now in the Mob Museum in Los Angeles. So that was the first shot fired across Costello's bow. And obviously the hitmen were all emissaries of Genovese. The second thing that happened was that Costello was going home to his fancy cooperative apartment on Central Park West, and he was approached by a Genovese henchman named Vincent Chin Gigante. And Chin Gigante withdrew a pistol from his pocket, and he said, "This one's for you, Frank." And Costello whirled to see who was calling him, and Gigante discharged the pistol, and the bullet grazed Costello's ear. Had he not turned around to see who was calling out to him, he probably would have been killed. But of course, Costello said he couldn't identify who his assailant was. And at that point, Costello said, well, it's not worth the trouble. And he agreed that he didn't attend the Appalachian meeting, but it was at the time of the meeting, it was agreed that the Costello would be given just a few of the gambling, narcotics, and prostitution crumbs, and the rest of particularly the drug trafficking business, which was the most profitable, would be retained by Vito Genovese.
And the talk about going and getting therapy and going to psychoanalysis, which mobster was that?
Oh, well, that was Frank Costello. Frank Costello was a dapper guy, and he was kind of a wise guy, no pun intended. But he saw a psychiatrist. And
that was the basis for Sopranos, seeing a psychiatrist.
That was the basis for both Analyze This and The Sopranos. But it was funny. Costello appeared before the Kefauver Commission. And, of course, the senators are all lined up there. And Senator Rudolph Halley, who was the counsel to the Kefauver Commission, said it's all on national television. It was one of the early investigative hearings to be nationally broadcast. And Rudolph Halley, the counsel, said, I know we got a question like this. He said, "Mr. Costello, can you think of one thing you've ever done for your country?" And Costello said, "Well, I pay my tax." And everybody laughed.
Lastly, we just have a few more minutes, so we'll save the best for last, and that would be the sex cases, or the pornography cases, I guess I should say. I guess some of the biggest ones were tried in the court. What's your book cover on that?
Well, I started in the mid-1930s with a novel by James Joyce called Ulysses, which had about 900 pages.
Who can read that?
And who could read that much? And one page, according to the government, one chapter was dirty, and it had a masturbation scene. And it came before Judge Woolsey, who was an extraordinary judge of the Southern District, and he read the whole book, and he wrote an opinion in which he found it not to be obscene. It was affirmed on appeal, and he said that the court has to not just read the dirty parts, or the allegedly dirty parts, has to read the whole book and take the work as a whole. And it was a landmark opinion, and when the book was published by Random House, Judge Woolsey's opinion was the preface to the book, and it made it the most widely read judicial opinion in history, I think. But there's been repeated reference to the Mother Court, which is the title of my book, and I think I should say it's called the Mother Court because it's the oldest federal court in the country, the Southern District of New York. It's 2 weeks older than the United States Supreme Court, and it's also called the Mother Court by lawyers because it's considered to be America's greatest trial court.
Well, and that's the name of the book, The Mother Court by James D. Zirin. And the other famous obscenity cases that were in the Southern District were the I Am Curious Yellow, and that was another a movie. And what was Deep Throat also litigated there?
Deep Throat was also litigated there.
And of course, we look back on that now, and of course, that sort of thing now. It's just kind of funny now. You look back and you say, "Gee, this was actually there was an argument over whether this would be in society." And of course, now it's amazing how we've moved on from that sort of thing, isn't it?
Yes, well, of course, contemporary community standards have changed, and with the advent of the internet and technology, it's virtually impossible for the government to prosecute pornography anyway. But we've just become inured to it, and those that want to look at it can look at it, and others can look at it but keep it from their children, and or not as they choose.
How do you feel about the way the court, the progress of the justice system now as opposed to the way it was then?
Well, that's a very good question. I think that the Southern District of New York, the Mother Court, remains cutting edge. The recent appointments to the bench have been just spectacular. It continues to have cutting-edge cases. The Edith Windsor gay marriage case, which successfully challenged the Defense of Marriage Act, the national security case involving the metadata recording of every phone call, every email in the United States, at least from and to whom, and perhaps even and the duration of the call, and all of these cases are cutting edge. They've all been decided in very innovative and interesting ways, reflecting the changes in our society, including technological changes. And I think what I miss about the court today is that I miss these unique judges who conducted trials there, trials in which there was a great deal of drama. It was that drama that got me hooked on being a lawyer in the federal court in the first place. And now, instead of looking into the eyes of the witness, the judge is looking at a computer screen. Documents, instead of being read, are flashed on a screen by the lawyer, and then a sentence here and a sentence there are highlighted, and it just the cases don't unfold with the same crispness and drama as the ones I participated in and the ones I witnessed in the mid-20th century.
And cases don't go to trial as much anymore either.
No, they don't go to trial. Criminal cases don't go to trial because most of them result in a plea bargain, and more result in a plea bargain than used to, because the judges have less discretion in imposing sentences and follow the sentencing guidelines. And civil cases get settled too, because somewhere along the line they seem to get settled, and the judge will try to get the parties to settle and try to avoid the expense and uncertainty of a trial.
Yeah. Fortunately, more and more of these judges are deviating down from these mandatory these guidelines. Just had a sentencing.
That is fortunate, and the Supreme Court said that they could, and although their first frame of reference is the guidelines, and there's always the danger that they'll adhere to the guidelines.
That's right. I had one the other day where 24-year at the low end, and fortunately the judge only gave him the mandatory minimum plus 5 months, so 125 months instead of 24 years. So that was Judge Jackson over here in Norfolk Federal Court. Listen, the name of the book is The Mother Court, because it is the mother of all courts in this country. It's the oldest federal court in the country, and we've spent the last hour with James Zirin. Any final words, Jim?
No, as you said, the hour passed very quickly, and that it was certainly the Mother Court gave me great excitement and great drama in my life, and I hope reading this book will prove to be just as exciting and interesting to whoever wants to read it. It's written not only for lawyers, but really for anyone. It's
a great read. Thanks for coming on.
I'm delighted to be with you, George. Thank you.
All right. We have spent the last hour with Jim Zirin, the author of The Mother Court. This is Justice